Good afternoon, everyone. On behalf of the Australian Law Reform Commission, it's my pleasure to welcome you to today's webinar. Our topic for today is What Goes Where? A comparative discussion of the legislative puzzle. It's pleasing to see the level of interest in the seminar with hundreds of registrations and participants joining us from around Australia and beyond. For those of us here in Perth, we acknowledge the Whadjuk people of the Noongar Nation as the long-standing traditional custodians of the land in this place. We pay our respects to all elders, past, present and emerging, and acknowledge the standing of all First Nations peoples. This webinar is part of an ongoing series to explore matters relevant to our inquiry into the simplification of financial services laws in Australia. Recordings of previous webinars can be found on the ALRC website. We're always happy for traffic on our website. May I begin with a brief background of the work that the ALRC is doing in this area. In 2020, the Commission received terms of reference to inquire into the simplification and rationalisation of the regulation of financial services in Australia. Since then, we've completed our interim report A, which is now available. It dealt with the use of definitions and terminology, particularly the key concepts that set regulatory boundaries. Later this year, we will publish interim report B, which will address regulatory design and the appropriate approach to the overall legislative hierarchy. This is what we refer to as the question of what goes where. Next year, we will complete the reference with a third interim report, which will consider how Chapter 7 of the Corporations Act might be reframed for greater clarity, coherence and effectiveness. Background papers relating to our work in this area can be accessed on the ALRC website. The task, of course, is considerable. We've estimated that it would take an average reader 40 days and nights continuously reading to complete the task of going through all of the existing regulation. The scale and complexity of the law means that there can be difficulty for those to whom it applies and those who benefit from its protections to find the relevant law. They need a way to understand the law's architecture. It should be well structured and signposted, but it also should be adaptable so it can deal with ever-changing financial markets. These requirements give rise to complex questions as to the way in which different parts of the overall regulation may be amended and updated over time, how appropriate exceptions might be provided for, and the best way to allocate those responsibilities to make sure the law is coherent and effective. Today, we are looking outside of Australia to other jurisdictions for insight and possible inspiration. We're seeking to learn from the approach to financial regulation in other places. Our panel of four esteemed speakers are each experts with experience in the design and operation of relevant legislation in their respective jurisdictions. It's my very sincere pleasure to introduce them today. Professor Julia Black will join us from London, where she is the Strategic Director of Innovation and Professor of Law at the London School of Economics and Political Science. Professor Black has written over 50 books, articles and policy reports on issues of regulatory design and dynamics, and was awarded a CBE in 2020 for her contributions to the field. She's also an external member of the Bank of England's Prudential Regulation Committee, a Fellow of the British Academy, and an Honorary Fellow of Lincoln's College, Oxford. Mr. Ross Carter is a member of the New Zealand Parliamentary Counsel Office with extensive experience in drafting government bills and secondary legislation. Previously, he worked for the New Zealand Law Commission. Ross is also an adjunct lecturer at Victoria University of Wellington and co-author of the leading texts Subordinate Legislation in New Zealand and Statute Law in New Zealand. Ross is also Secretary of the Commonwealth Association of Legislative Counsel. We also have Professor Hans Tjio, who is the CJ Co-Professor at the National University of Singapore, where he teaches regulation and trust law. Professor Tjio has published widely on company law, securities regulation and trust law. He's previously undertaken secondments with the Monetary Authority of Singapore and the Ministry of Law. He also serves on the Security Industry Council of Singapore and the SGX Listing Advisory Committee. Professor Wei Wan is the Associate Dean of Research and Internationalisation at the City University of Hong Kong. Professor Wan's main areas of research include corporate law, mergers and acquisitions, securities regulation and financial consumer regulation. She has previously worked as a partner at Allen & Gledhill in Singapore, where she practiced in mergers and acquisitions and capital markets, and also at the Singapore Management University as Dean of Postgraduate Research Programs and Professor of Law. I extend a warm welcome to our four speakers today, and those brief descriptions of their CVs indicate that we are in for a well-informed discussion and presentation today. One of the big questions for today's seminar is, what is the right framework for the laws that regulate financial services? Can it be done without clutter and obscurity? Is there a better way in Australia of expressing the laws to encourage compliance and understanding of the obligations? One issue is how to deal with offences and penalties. To what extent should they be in the main legislation given their coercive character? When is it appropriate to use delegated legislation to impose penalties, and how should that work if that is done? With that introduction, I come now to introduce Julia Black to start our discussion. So over to you, Julia.
Thank you so much, and good evening, good afternoon, everybody. Good morning for me, but thank you so much, Justice Colvin, for your introduction and your very kind words. I'm delighted to be able to speak with you this morning, and I'm going to talk about two things. I'm going to talk about generally what we might think of in kind of technical, functional terms of the best design for a rule system. Rule system is only obviously part of a regulatory system, but is a key part. And then I'm going to just move on briefly to discuss the experience that we're having in the UK, having been part of the EU and their rule system for financial services, and how that itself changed post the financial crisis. And then just introduce to you a little, very, very briefly, the very complex situation we have at the moment and what I call the great sorting out once we've onshored that EU legislation into our UK law. So I'm just now going to share my screen, which, as all we know, all presenters have a little moment of panic at this point, hoping that they will actually be able to find their slides. Let me just find those for you. Needless to say, I can't show my slides, so I'm just going to carry on and hope that you can hear me, and they will be available for distribution. My apologies for that. So, choices in designing rule systems. We have a range of choices when deciding how to design our rules. They are about the rules themselves, but also about the systems that we are looking at in terms of the overall institutional design of those systems. So in terms of the rules themselves, then you have rule choices. You've got, in terms of their linguistic structure, you can think about how detailed the rules are. You can think about how general they are. You can think about how they're simple or complex. Oh, here we go. And we can also think about their overall certainty that they might be giving in the way that they're phrased. We can also think about their overall status in terms of whether they are legally binding Obviously, we're talking here about legally binding rules, but whether they're going to be criminal, strict liability offences or other requirement of intent, and if they're civil or administrative, or if what role it's going to be played by non-legally binding rules. And if it's guidance, does it have evidential status? So in the UK, for example, we have certain pieces of guidance. Our highway code is always a very good example, whereby breach of the code itself doesn't necessarily mean that you've broken a rule, but it does provide evidence of breach of a rule. Or are that guidance going to be simply entirely non-binding through codes? And then we have to think about, so that's rule type. And I think what we forget sometimes in the discussion is that there's a separate set of considerations about the institutional framework, where we think about who's going to be the author of those rules. Is it the legislature? Is it the executive? In a federal system, what's the distribution of responsibilities between federal or state, or in regional, such as the EU, between the EU institutions and member states? Is the author going to be a regulatory agency? Again, federal or state, at what level? Is it going to be a private actor or organisation? And it's worth bearing in mind that in terms of the linguistic structure of the rules, any of those authors can write rules of any type. So there's no necessary reason why, for example, a legislature has to write specific or detailed rules. There's no necessary reason why private actors or organisations are writing general rules. Obviously, private actors may actually be given powers to write rules which will have legal effect. So there's no necessarily line up, as I say, between rule type and author. But we also then need to think about the enforcer. Penalties has been raised already. What right of private action is going to be given? Are we going to be relying on people taking actions in court against the person that they think has breached the rules? We're going to have a public actor, a regulatory agency, for example, whose role it is to enforce. Are we in a more private system thinking about rules of contract, membership of self-regulatory bodies, supply chain conditions, etc.? And then what's the adjudicatory body going to be? Is it going to be a court, a specialist tribunal, a regulatory agency? Or they have powers to impose sanctions, and if so, with what kind of appeals and what kind of guarantees around the independence of the process, etc., and others. So that's the choices in designing our rule system. So that's really what's an issue here in the Australian context. In terms of the what goes where, then I think it's worth thinking about those different aspects of both rule type and institutional framework. So then if we move on to think about, okay, well, a lot of things to think about, so how are we going to think about them? And think about factors to consider in making choices on rule system design. I've just bunched them broadly into three categories. So we've started talking about the functional, which is obviously, you know, what do we want the rule system to do? Ultimately, we want it to be able to achieve the social goals that we're setting out to try and achieve. And how is it going to do that? And the first thing you have to remember about rules is they are instruments of communication. We don't think about this as lawyers necessarily. We think about them as instruments to, you know, hold people to account, provide enforceability, etc. But if you're in a regulatory context, then what's really important is you communicate very clearly to people the behaviours that are expected of them, whether that or the model, what it is that they need to do. And I think we lose sight of that, but I think that's something that's coming out very strongly in the Australian context at the moment, which is, well, nobody can, the rules aren't communicating anything because the system is so complex. So I've put communication as the first thing that rules really have to be able to achieve. Then, as has been mentioned, the need for adaptability, and that comes both from the rule type and the institutional framework. And again, important not to conflate those two things. You can have lots of detail and complex rules if you've got an institutional framework which requires easy adaptability of those rules. Where it's difficult to be changing the rules, those particular rules, then I would argue for the sake of adaptability, you need more general rules, more framework type rules. So that goes very much to the what goes where discussion. How easy is it to change this rule, given its author and author's position in that institutional framework, and how difficult it is going to be to change that particular rule? Enforceability, referenced before, again goes to rule type and goes to the need for people to understand the behaviours which are expected of them, if those behaviours in particular are going to be, if they don't follow that, it will be a legal offence. So again, got to think about the rule type and the institutional framework. Also got to think about the capacity of the actors to make the rules. And that is their expertise and their authority and their legitimacy. And this is obviously what always comes into discussion in the regulatory context. Where does that expertise lie? And usually, to be honest, that expertise lies in an expert regulatory agency rather than in government or in a civil service, particularly, for example, the UK model of the civil service, which are generalists who rotate around on 3 or 4 years across different departments, and so are always less expert in the area than the regulator, of people who spend, their entire lives either in private practice or in the regulator working in the field. And then there are other considerations that come into play, particularly in federal systems, about coordination across states, about harmonisation, and those became very, very much to the fore in the EU context, which drove a lot of the other decisions about rule type in a way and rule system design in a way I'll go on to explain. So then we can also think about constitutional values, incredibly important, already referenced, the rule of law values. Whether law should, the fact that law should be open, accessible, certain, predictable, etc. You need to think about democratic values, democratic engagement, the accountability to legislative, executive courts comes very much into play in our decisions as to regulatory bodies and the roles that they have in rulemaking. Things about distribution of powers, of federal, regional, etc. And then finally, last but certainly not least, is just political power and control. How much power and control does the political principles, those in power want over the ex-ante determination of the rules? What engagement do they want during the regulatory process? For example, powers to give directions. To what extent are regulatory agencies going to be independent from political influence? And how do we draw the line between legitimate accountability concerns, which are often ex post, and an unacceptable politicization of the regulatory process? And that's a very difficult boundary to draw, and is usually not one which is actually can be drawn so much in law. It has to be one which is more determined by behaviour. And all of these considerations feed into the what goes where debate. So thinking purely functionally, we'd have a rule system which combines rule types with a clear institutional framework. So, for example, enabling legislation sets out the key provisions, including the goals of the system, the powers and duties of the other actors, the key elements of the regulatory provisions, defining the perimeter, stipulation of the overall framework, specification of offences, but that could be quite general. It could say, for example, it is an offence to breach a regulatory rule. And that's the system we have in the UK. So that is a way then of not requiring everything to be written in your primary legislation, but you are doing quite a significant delegation to your independent regulatory agency if you're giving them powers to write laws, which they are being given, and any breach of those rules will be some kind of offence, even if it's just an administrative action will follow. If it's criminal offence, that will be written in the statute, but administrative offences, that is specified in the statute, but the detail is obviously laid out in the regulatory rules. And then obviously a specification of the enforcement processes, including rights of appeal. And then what you would have in your secondary legislation, more detailed provisions, and those adaptability mechanisms. So powers and processes to enable the adaptability of the system, for example, to extend the regulatory perimeter. Now, in the UK, we have 2 modes of secondary legislation, and Parliament's involvement varies with each. We have a type of secondary legislation which passes by what's called negative resolution. So that is that as long as Parliament doesn't object, the rule comes into force. The delegated legislation statutory instrument comes into force, or positive resolution or affirmative resolution procedures, whereby it requires Parliament to actually affirm and agree to the statutory instrument before it comes into force. The latter obviously gives more parliamentary control and is used for more important changes and adaptations. And then the regulatory rules contain actually statements of principle. So again, going back to my different types of author, can write rules of all sorts of different types. Statements of principle which elaborate the statutory goals and the various have regards that might be set out in the legislation. and contain then the detailed and technical provisions. And then there's regulatory guidance which elaborates on how to comply. So that, if you like, is a sort of rule pyramid. So you've got different things happening at different levels of the institutional framework, with different with your more general sort of framework in the legislation, because that's very hard to change. And then the more you're coming down the framework, you've got the more detailed provisions in the regulatory rules, so including statements of principle, but they are much easier to change. But functional considerations are never the sole driver. And just to talk briefly in the last couple of slides about the EU and UK experience. So in the EU, there's been a drive for a single capital market, which is work still in progress. But back in 2001, there was something called the Lamfalussy reforms, which started to sort out, as it were, the rule hierarchy in a way that actually looked quite similar to the British system, which you have directives and regulations agreed at the political level. So in the EU system, you may or may not be aware, but directives are to be implemented as to intent in the member states, and regulations are directly applicable. And then the detailed provisions be made by the Commission at level 2, and then the member state regulators would give guidance on implementation, and the Commission would then monitor implementation by the member states. Then the crisis comes along, and one of the issues that quickly arose in the crisis was the issue of both of regulatory arbitrage and of the weakest link, a recognition that a system of a rule system, and as part of a regulatory system, is only as strong as its weakest link. And so there was a great and swift use, to a much greater use of regulations, which are directly applicable. No amendment by or elaboration by member states; they are directly applicable. And for directives, a stipulation of maximum harmonisation measures. So in other words, you basically had to just write out the directive. Nobody could go above it, nobody could go below it. And that was to ensure uniform adoption across the member states. Then at level 2, you have the creation of 3 committees who draft technical standards, which are approved by the Commission, and again are directly applicable in member states. So the point being, we had post-crisis significant, because it was basically a wholesale reform, significant parts of the EU legislation was directly applicable by two member states. So they were then, to the extent that they were directly applicable, they didn't need incorporating in any UK law, and to the extent that they needed incorporation, that was mainly done through regulatory rules, because the regulators were national competent authorities for the implementation. So what happened then, as Brexit starts looming, then there's a recognition that there's a whole pile, literally a lot of law, not only in financial services, which is sitting on the EU rule books, which is not sitting in the UK rule books or statutes anywhere, because it was directly applicable. And so under the EU Withdrawal Act, that whole body of EU law had to be incorporated absolutely wholesale, lift and shift, into primary or secondary legislation, which was called ensuring the acquis. So it literally was a lift and shift. Lift it, take it out, and just put the UK in front of it. Take out, literally do a control and replace on anything mentioning EU or recognition of kind of reciprocity across member states, and refer just instead to the UK instead. And in some cases, the FCA and the PRA were given powers to amend some rules in some areas. And remember, financial services has the international framework as well, so we have that to consider. So now what we have to do is the great sort out, as I say. So Financial Services Act 2021 started that process, provided for the adoption of in-flight EU financial services laws, so those which have been negotiated and agreed, and in fact quite heavily influenced by the UK in some cases, but not yet formally enacted, Basel III and Prudential Regulation of investment firms in particular, to be brought in, and the Treasury to amend some of those, and the FCA and the PRA to amend and implement some of those in-flight rules themselves. And now what we have had is the consultation on the future regulatory framework review, which I call the great sorting out. We now have provisions scattered across our regulatory rule books, secondary legislation, primary legislation. We've got enabling provisions in the regulatory rules, where the detail of those is actually now in the statute. Everything is upside down. And so we've got to have a reorganisation of the rule system, which means going back to that institutional framework, there's a big revisit of the issues of regulatory independence and accountability. And so we're revisiting the discussions that we had back in 2000 when the Financial Services and Markets Act was being formed around the nature of the independence of our regulatory agencies, the nature of their powers, and the nature of accountability control arrangements that should surround them. So I'm going to stop there, but just to give you a little flavour of the types of debates we're having in the UK right now. Thank you.
Thanks so much, Linda. That presentation frames perfectly the discussion for today, which focuses on legislative hierarchy and the issues which it raises. I was struck by the significance of expertise for those actors, but also what can happen if you have to turn upside down all of your laws in this particular area. Our next speaker is Ross Carter. As we've seen, the law in this area relies ordinarily on delegated legislation. It also can depend upon, needs to depend upon, soft law instruments and formal guidance from the regulator. These approaches provide detail and adaptability within the legislative scheme. So effective delegation is appropriate, but its oversight and who is entrusted with that power is critical, as is maintaining coherence within the layers of the legislative hierarchy. So these are matters that were commenced through our interim report A. Ross, of course, is at the practical end of this, drafting these matters in the Parliamentary Counsel office on a regular basis, and we now look forward to your thoughts, Ross.
Well, thank you very much, Justice Colvin. Ina mana, ina reo, ina ka rangantaha maha tēnā koutou katoa. All authorities, all voices, the many affiliations, greetings to you all. Hello, I'm very honoured to take part in this webinar with Justice Colvin and Professors Black, Tjio and Hon. My views are not views of New Zealand's government or Parliamentary Council office, they're my personal views as a full-time New Zealand legislative drafter for nearly 25 years. Now, New Zealand drafters collaborate to try to achieve great law for New Zealand, which means law that is accessible, fit for purpose, and constitutionally sound. Dividing material well between acts and secondary legislation is a core design issue. Most acts involve secondary legislation, especially large and complex ones like acts for corporations and financial services, income tax or social security. New Zealand's large acts use a lot of secondary legislation, and here are some examples. Our Financial Markets Conduct Act of 2013 replaced all or part of 6 former acts, and it weighs in at 497 pages. There's one main set of regulations under it that is longer again at 655 pages. Our Income Tax Act of 2007 is 3,744 pages and is accompanied by a Tax Administration Act of 828. There are, under these 2 acts, at least 21 sets of secondary legislation. Our Social Security Act of 2018 is 465 pages, and one main set of regulations under it is half as long again at 233 pages. But these are quantities, not qualities. So what should Parliament delegate, to whom and why? These are great design questions, and a full review certainly helps to allow good answers to them. Amendments over many years for many different policies can increase incoherence. New Zealand has established principles and practices for delegating powers to make secondary legislation. Key general principles and practices are set out in New Zealand's Legislation Design Advisory Committee, or LDAC, guidelines of 2021 and New Zealand's Regulations Review Committee, or RRC, Digest of 2020. And similar in the UK, of course, is the House of Lords Delegated Powers and Regulatory Reform Committee's compendium of legislative standards for delegating powers in primary legislation. These sort of design principles informed the bill for New Zealand's Financial Markets Conduct Act. For example, they informed use of regulations to supplement or modify the Act's express transitional provisions. They also ensured that exemptions are linked to and constrained by the purposes of the legislation. Secondary legislation, perhaps because its use was principled, was apparently not controversial in that reform. A principled legislative hierarchy, the Australian Law Reform Commission has said, would likely involve the core attributes of a regulatory regime being outlined in the Act, with detail added by regulations and potentially exemptions or administrative minutiae provided for by legislative instruments. That is a useful general summary, but because of its generality, it does not show in detail exactly what goes where. In a principled hierarchy, the legislature, not its delegate, decides core attributes. Also, the legislative scheme is legitimate, it's durable, it's flexible, certain, and accessible. Now, there can be tension in these important aims, so they are to be balanced. The principled hierarchy follows and shows a clear and principled plan for delegation. Core attributes, for example, key purposes, principles, and concepts, are in the Act, but secondary legislation can add detail and cover, flexibly, exceptional situations. For example, New Zealand secondary legislation can only prescribe minor offences for breaching regulations or infringement, more minor fixed penalty offences. Statutes should generally set out the policy and substance of the law, even if emergency laws like those for COVID-19 are limited exceptions to that proposition. Our 2018 Social Security Act moved 17 groups of provisions in the former 1964 Act to secondary legislation. Our Regulations Review Committee said this was, quote, a major rebalancing, quote, but also, quote, in general, a balanced approach. The bill's rebalancing was accepted to be principled, balanced, and moderate. The bill followed a clear and principled plan for delegation, influenced by Legislation Advisory Committee, or LAC, guidelines and the work of Professor John Burrows QC. Main benefit eligibility provisions are in the Act, but rates are adjustable by regulations. For supplementary assistance, broad parameters are in the Act and details are in regulations. The Act also allows for hardship and emergency assistance by conferring discretions to allow flexibility and responsiveness, with further details in regulations and in ministerial welfare programs. The Act also has simpler and more general administrative provisions to allow more detail to be in regulations. There remain 5 main different types of secondary legislation under the Act. Most are both drafted and published by PCO, but ministerial directions and notices are drafted and published by the department. All the secondary legislation is subject to scrutiny and disallowance under the Legislation Act of 2019. Some of it, now happily excluding mandatory orders increasing rates of benefits, is also revoked unless earlier confirmed by Act. In time, nearly all secondary legislation is to be published on one legislation website. This will help users access all relevant pieces of the puzzle. New Zealand reformed in 2021 all its secondary legislation powers. The reform was prompted by various reviews and reports. One was a December 2013 report on an inquiry into a big food safety scare, an incident of possible contamination of dairy whey protein concentrate, which caused concern about safety of infant formula and other dairy products. The inquiry was led by Miriam Dean QC, and its report showed major concerns about fragmentation and accessibility of legislation regulating dairy factories. The inquiry noted the lowest layer of regulation by itself was about 12,000 pages, taking up more than 3 meters of shelf space. It said submitters noted this layer as, quote, difficult to navigate, quote, inaccessible, and, quote, a bit of a nightmare. The inquiry recommended consolidating and rationalising with expert drafting help from a centralised drafting office, the PCO, starting with design and planning of enabling provisions in the primary legislation. It added, quote, creating a set of simple rules of general application for the creation, amendment and publication of all secondary legislation would also result in order, continuity and better accessibility. In New Zealand's statute book as a whole, as at the end of 2021, there were just under 2,000 empowering provisions for PCO published secondary legislation and just over 900 where a different agency drafts and publishes. So a little over a 2-to-1 ratio of PCO published versus agency drafting and publication. Of those 900 non-PCO published secondary legislation powers, about 42% do not require publication on any website. Using secondary legislation too much to alter core attributes or to clarify interaction with other regimes shows core policy has not worked out well, and that core attributes of a durable and flexible scheme are not in the Act. The Act and secondary legislation are complex and conflicting, not simple and coherent. Simplicity and accessibility can suffer. New Zealand has good safeguards for secondary legislation. They include clear principles, detailed powers, preconditions, for example, consultation, affirmative resolutions in some cases, PCO certification, exposure drafts, regulations review committee scrutiny, and judicial review. Sunsetting and confirmation, either by Act or by resolution of Parliament, can also apply. Generally, this works well. Judicial reviews of COVID-19 legislation show the duty to legislate consistently with the New Zealand Bill of Rights Act of 1990 is a meaningful duty. An example is the recent case of Yardley against Minister for Workplace Relations and Safety, where a vaccination order was set aside as limiting rights unjustifiably, and the order was not needed for the specified purpose of ensuring the continuity of and trust in public services. But design has to be careful, collaborative, and principled. A few recent examples show some areas of particular scrutiny and possible demonstrable improvement. In order modifying immediately for COVID-19 reasons, general employment law was held to be subject to an implicit duty to review the need for the order in the case of Ideas Services Limited and Attorney General. It was held there was an unlawful failure to review the need for the order. The Empowering Act should arguably also have included an express duty to review regularly the need for the order, just as it requires the triggering epidemic notice to be kept under review. The order has since been revoked. New Zealand's Review Committee has also criticised recently New Zealand's COVID-19 Protection Framework Order for its complexity and for containing provisions that are not activated or applied to any area at any time. This drafting approach was taken to optimise flexibility and speed of drafting. The Regulations Review Committee's work in this area is ongoing, and others, such as our Law Commission, are also reviewing these laws. The Empowering Act may not contain enough core attributes of the scheme, but emergency legislation must also be flexible and responsive to changing facts. Hindsight is a wonderful thing. A view that secondary legislation contains matter more appropriate for the Act often also involves regret about overbroad delegation. Accessibility is certainly improved by making all relevant secondary legislation findable on or through one website. It is also improved by minimising items of secondary legislation under an Act and making very clear how they interact with the relevant provisions of the Act. If secondary legislation overrides an Act, and some does, then arguably the secondary legislation should also amend the Act to make this clear, so helping users. As UK Legislative Counsel Daniel Greenberg notes, the real question should be what substance is it appropriate to delegate, not the form of the secondary legislation modifying an Act. As Western Australian Legislative Counsel Lee Harvey adds, we should also be on alert for developments that undermine the effective operation of legislation without proper analysis of principles. As the High Court of Australia Justice Stephen Gaigler said in 2014 in the Good Apple case, empowering provisions of this kind, quote, reflect not a return to the executive autocracy of a Tudor monarch, but the striking of a legislated balance between flexibility and accountability in the working out of the detail of replacing one modern complex statutory scheme with another. Complexity and fragmentation is also apparent in recent COVID-19 modifications and protocols relating to New Zealand's Juries Act and jury rules. The modifications and protocols override temporarily that Act and those rules. The Parliamentary Committee that scrutinised the bill for the empowering provisions clarified how the new protocols interact with the Juries Act. As published at the legislation website, the Act and the rules will indicate that they are affected by the modifications and the protocols that are issued by judges and published on the website of the Courts of New Zealand. Even though the secondary legislation is COVID-19 related and is temporary, while in place it involves a complex set of provisions in different places for users to piece together. In practice, I suspect people summoned for jury service and jurors will rely heavily on guidance. So that concludes my remarks, and back to you now, Justice Colvin.
Thank you so much, Ross, for that presentation. I was struck by your use of the term findable. I think we might pick up on this idea of findability and the use of websites, the practical technology as a way of gaining access to legislation. But I sense from your presentation that these issues have been considered quite carefully in New Zealand, and there were lots of great insights in there, so thank you. Our next speaker is Professor Hans Tjio. By way of introduction, a recent background paper published by the ALRC highlights the way that the regulatory approach to disclosing risk has changed over time, and the result has been the addition of new layers of regulation. The old has tended to remain with the new, making for a confused mosaic in which the foundations don't always neatly fit with later extensions and additions. New rules become added without addressing existing ones, and this adds to complexity and uncertainty. Singapore, I think, in this area has a reputation for reviewing and updating its approach to regulation in a considered way. So I look forward now, Hans, to your insights with the perspective from Singapore. So over to you, Hans.
Thank you, Justice Colvin, for this opportunity to present the view from Singapore, which is usually a price taker. As our first Prime Minister, Lee Kuan Yew, is reputed to have said, we should not reinvent the legislation wheel, especially if it works well. Good afternoon, everyone. I'll try and share my PowerPoint. The reality is that many aspects of our laws were drawn from the UK and Australia, our Companies Act 1967. We recently went back to renumber them based on their original year of enactment. It was actually based on the UK Companies Act 1948, which was then the 1961 Victorian Companies Act. Similarly, our present Securities and Futures Act 2001, which merged the previous Securities Industry and Futures Trading Acts, were actually drawn from the New South Wales Security Industry Codes of 1980 and the Futures Trading Code of 1986. We have, of course, amended things substantially along the way, but I hope to highlight some areas which may be of interest. We did not, however, review much of our corporate and financial legislation from enactment until after the Asian financial crisis in 1997-98. There were few, if any, earlier systemic shocks that required it. After that, in the years 1999 to 2001, there were many consultation papers which suggested substantive changes. The philosophy behind those papers have been unchanged, but the two later reviews 10 years apart. These included the need for companies legislation to focus on small companies, the simplification and modernization, and the building on our UK heritage, rather than moving towards the US laws due to the needs of capital, save for one exception, which are the insolvency rules that we have amended since 2017, which have aspects of Chapter 11 woven into them. The third philosophy was that listed company provisions were to come under the Securities and Futures Act, where these were possible. So unlike in Hong Kong, prospectus requirements are found not in the Companies Act, but in the Securities and Futures Act. Then there's a separate omnibus insolvency and bankruptcy legislation. And then finally, the greater use of civil penalties, even if not civil liability. Where delegated legislation was concerned, however, all the papers were clear that it should provide for perhaps less important matters such as technical, procedural, and operational details, as well as administrative sanctions. As the position then in 2000 was still that most of primary legislation was backed by criminal sanctions. The first point regarding lesser substantive consequences in delegated legislation is still true, except that in areas where the market changes rapidly, some substantive provisions have been moved to subsidiary legislation. The examples that we have from our Securities and Futures Act is with respect to the conduct of business rules, such as licensed persons having to give priority to a customer's order, as well as trading as principal. These were moved out of the Act and are now found in delegated legislation, largely because market practice changes so fast. We saw that keeping the provisions in the Act would require too many no-action letters, which could eventually erode the meaning of the statutory provisions. The principle still remains that the provisions in our Securities and Futures Regulations, i.e. subsidiary legislation, flow from the overarching ones in the Act. But it is the latter concerning the divide between criminal and civil sanctions that we have seen the largest changes, with even the Securities and Futures Act itself allowing greater use of civil penalties. This has become the most popular sanction for insider trading and other forms of market fraud. For empirical studies, civil penalties are used even more so than in Australia and Hong Kong for insider trading and market fraud. Many of these are settled directly out of court with the Monetary of Singapore. In contrast, company legislation does not provide the corporate regulator, or accounting and corporate regulatory authority, power to obtain civil penalties, even in court. And so much of the enforcement remains in the criminal domain only. The result of having to work with the public prosecutor means that the number of actions are comparatively lower than the Monetary Authority of Singapore. For example, like in Australia, all breaches of directors' duties can only be enforced by the state by way of criminal action. There's no ability to obtain civil penalties for less serious breaches. For us, the problem may be not just with moving less serious matters into delegated legislation, but also decriminalizing more of our primary legislation. This will then also allow people to start seeing our corporate legislation as more facilitative than mandatory in nature. At the moment, there's still many who believe as a starting point that you cannot derogate from the Companies Act, even if, for example, you provide even greater protection in the corporate constitution than the Act provides. So an academic view from Singapore is that there should in fact be greater delegation to administrative agencies as opposed to relying too much on the legislature and courts. There's little concern with overreach as the regulators are clearly more in tune and sensitive to the markets. In any case, all subsidiary legislation must be presented to the Presidential Council of Minority Rights within 14 days of publication. Judicial review should also be possible in respect of any exercise of powers granted to the agency, which would include making subsidiary legislation that may be ultra vires the Empowering Act. So, for a small jurisdiction like Singapore, I believe that the benefits outweigh the costs. The benefits of delegation outweigh the costs. For example, with respect to one area which the Australian Treasury is looking at, which is the insolvency and restructuring of business trusts, the Securities Industry Council, which is housed in the MAS, this is the equivalent of the UK takeover panel, I looked at this issue some 10 years before the first court judgment on the matter in 2017. The High Court, in fact, relied on the practice statement issued by the Council in 2008 in deciding that it was possible for the corporate scheme of arrangement to be used for the trust restructuring, for the trust to be restructured as an entity, as opposed to individual trustees being wound up or restructured at that level. At the moment, however, it seems that there is more regulatory administrative deference to the Monetary Authority of Singapore, which is an independent statutory board. This is with respect to financial regulation. In contrast, corporate legislation is still overseen officially by the Ministry of Finance, rather than the specialists at the Accounting and Corporate Regulatory Authority, i.e. ACRA. Consequently, both the public prosecutor and the courts may not provide them as much leeway with respect to the legislation they oversee. There's always a tension between generalists and specialists, but when things change so quickly, it is necessary to trust in regulatory discretion, and that may be true not just of financial, but also increasingly corporate legislation. This is necessary as the divide between securities of financial regulation and corporate legislation is not altogether clear. For example, there was much debate after the 2011 major corporate law reform exercise in Singapore, which was 10 years after the first, and we're now undergoing our third. There was much debate as to where to move provisions in the Companies Act relating to listed companies. The suggestion was that they should remove the Securities Futures Act, which concerned largely securities on exchanges. Eventually, however, only a few were moved as the government realized that provisions relating to listed company matters, like the Audit Committee or capital maintenance and on-market buybacks for listed companies, had to remain in the Companies Act. Due to such costs involved for practitioners and the complexity of duplicating definitions, it can be argued that the share purchase provisions, for example, should continue to be located where similar provisions are located in equivalent legislation around the world. This would usually be in the Companies Act, with its exceptions on how much can be bought back in a year, for example, even if there are other provisions in securities legislation, or more likely, exchange rules, which provide safe harbors for buybacks from the insider trading and market manipulation rules. While you do not have this problem in Australia and wondering which piece of legislation to look at, I guess we're gathered here today to look at the problem from the other extreme, which is that there's too much, in fact, that's consolidated in the Corporations Act overseen by ASIC. This is only said with great diffidence, as I've always been an admirer of Australian company legislation. But you may want to carve out securities and derivatives legislation, as in Singapore or Hong Kong, or slightly more broadly financial regulation, as in New Zealand, and perhaps even more, as in the UK. Solvency and restructuring has also become standalone legislation in many countries due to the complexity and links with personal bankruptcy. In Singapore, as I said, this has also been infused with some Chapter 11 provisions from the US. But this should all be driven by pragmatism rather than any dogmatic view of what is properly seen as financial, corporate, or insolvency legislation, as there will always be overlaps. These overlaps are what I imagine has resulted in the Corporations Act as it is today. But the question now is whether the use of technology, as was mentioned previously, for example, hyperlinks to definitions, online subsidiary legislation, practice statements, or interpretative notes can do the trick. It may be that no one actually relies on a physical rule book or statute anymore, but things can be improved even in cyberspace. I love the OSLI website, but a few years ago I wrote to them to tell them that in the Corporations Act, references there to a Part 5.7 body throughout the Act was unfortunately hyperlinked to the definition of body in the Section 9 definition. And this is quite different from a Part 5.7 body, which it should have been hyperlinked to. Now it seems that there's hyperlink to either body or to Parts 5.7 body. So in a sense, you're victims of your own success in Australia. I'm not sure on the cost-benefit analysis, given the expertise built up in ASEC, whether you should split your legislation up. In Singapore, as I've said, our companies legislation comes under ACRA, in the Ministry of Finance, Securities and Derivatives under the Monetary Authority of Singapore, and insolvency restructuring under the Ministry of Law. Although this lessens the load for any one institution, there will be coordination issues when an issue cuts across different regulators. One example of this in Singapore, as I mentioned earlier, was with the business trust. A recent example is with the special purpose acquisition vehicle. It is less of a problem in Singapore given its small size, but Australia has enormous geographical reach. Yet there's a great deal of regulatory deference and administrative deference given to your courts, to your regulators, as in the US. Whereas places like Singapore, the UK, and Hong Kong have perhaps less of it. So we in Singapore, we will be seeing the problem from a different perspective altogether, as we are not looking so much at safeguards, but more efficiency. I think we need to be clear in our minds to different questions asked by the ease of searching for the law, i.e. coherence and navigability, for which too much delegation may create problems, and dealing with complexity efficiently, which more delegation would help. The ideal might be more clearly defined and delineated legislation that's administered by a single agency. So we look forward in Singapore to what your next steps in Australia are. Thank you very much.
Thank you very much, Hans. It's very interesting to hear how civil penalties are being used by an expert regulator as a means of ensuring appropriate market behaviour. But I think the discussion about the demarcation between companies and securities regulation and two regulators is, of course, very interesting in relation to how our law is structured here. Even if you have one regulator, there are reasons why you may have a demarcation expressed in the interests of providing clarity as to those matters. So I'm sure we can have further discussion about that. Our final speaker is Professor Yi Wan. Some of the previous speakers, as I've indicated, have been talking about offences and penalties. Australia's civil penalties regime for financial services is something that has grown in detail. It's become quite long-winded and complex. It can be difficult to comprehend what's required to be done to obey the law and difficult to formulate appropriate compliance measures to deal with all the provisions that come within that kind of regime. These are particular challenges for those who are being regulated. So with those thoughts by way of introduction, we look forward to your thoughts, Yi. Over to you.
Thank you, Justice Colvin, for the introduction. What I'm going to do is that I will proceed to share my slides. Thank you again to the Australian Law Reform Commission for inviting me to this webinar. In this webinar, I will be referring to the history of the companies and securities legislation in Hong Kong. The way that I've approached it is to look at the rationale for the rewrite of the companies legislation, the hierarchy of laws, relevance of the rewrite exercise, offences and penalties, and some reflection. I follow a similar structure in relation to securities regulation in Hong Kong. So let me just explain the history of the companies legislation rewrite exercise. The companies ordinance, first found in Chapter 32, was enacted in 1865. Hong Kong was a British colony before it reunited with China in 1997. So the legislation, especially the companies legislation, has followed very closely to developments in the UK. And the major impetus for reform came in 1997, where there was a recommendation to confine companies legislation to what the consultant regarded as core company law. The Standing Committee was not so much in favor, but in mid-2006, the decision was made to rewrite the company's legislation for the main reason to modernize the company law in order to enhance Hong Kong's future as an international business and financial center. There were 5 rounds of public consultations, and the bill was introduced to Legislative Council in 2021 and finally approved, and it came into force in March 2014. Now, the way that the company's ordinance rewrite had taken place was that what is regarded as company law went into a new piece of legislation, Companies Ordinance Chapter 622, but provisions relating to prospectuses, disqualification of directors, and winding up were retained in Chapter 32. So in terms of the core objectives of the rewrite exercise, there were 4. One was to enhance corporate governance. The second was to improve the disclosure of the company information. Third, to regulate protection of shareholders, in particular through a number of prescriptive provisions on directors' conflict of interest. And the 4th was to enhance the minority shareholder protection, especially in relation to voting in privatization exercises. So the key, I think, impetus when we look at the period of time in question, we were looking at situations where there was a downturn in the stock market, and there were a number of privatizations largely carried out by controlling shareholders, and there was felt the need to be able to protect the minority shareholders. The second broad overarching objective of regulation was to ensure better regulation. This empowers the Registrar of Companies to have some powers to rectify documents in public registry and to improve the way that the charges registration regime works. So third objective was to facilitate the business by doing away with unnecessary requirements, allowing capital reduction to take place outside of court, and to simplify the reporting for the small and private companies. The 4th objective was to modernize the law by the use of plain English, abolish memorandum of association, and had a number of clarifications in relation to when directors can be indemnified against liabilities to third parties. So how does the hierarchy of laws work in relation to company law? So we have the broad legislation, the Companies Ordinance. We also have the Subsidiary Legislation. The subsidiary legislation in the context of the Companies Ordinance Chapter 622, they are called regulations. There are 12 pieces to support the main legislation. They include provisions relating to accounting standards, the form of reporting that is required for directors' reports, how information relating to directors' benefits are to be disclosed. The subsidiary legislation is delegated to the Financial Secretary. The reason and the rationale for having subsidiary legislation, as can be predicted, is to allow for easier amendments and updating into the future to take into account advances in technology, any new requirements in the market. So, for example, the subsidiary legislation on the company's directors' report regulations contain provisions on how the directors' reporting should take place in the format of the report, what needs to be disclosed. That was drawn up with the consultation with the Securities and Futures Commission and the Hong Kong Stock Exchange. These provisions on reporting are expected to change over time, and it would be extremely cumbersome to have to put these provisions into the main legislation. What has been useful, particularly to the practice, is that the company's registry also publishes briefing notes. The briefing notes provide some general information and the rationale for the subsidiary legislation on how to implement the main company's legislation. So in addition to the briefing notes, the company's registrar does issue guidelines indicating as to how the registrar performs the function or exercise of any power and provides guidance on how the company's legislation works. The company's ordinance explicitly provides that the guidelines are not part of the subsidiary legislation, though it's admissible in evidence. So the way that it works is that you have the main legislation, you have the subsidiary legislation, you have a series of briefing notes, as well as some guidance from the Registrar of Companies as to how the registrar can exercise his powers in the registrar has been conferred to. The rewrite exercise was considered a major one in recent history. The consultation papers remain available on the company's registry website. The website contains short papers as to how the new, well, now not so new, but the company's ordinance provisions that came into force in 2014 and what has changed from the position immediately preceding the law, as well as the rationale for the changes. The FAQs are also on the website with key changes on the topics, and as well as explaining why some of these changes have taken place. Now, in terms of the offences and penalties for the company's legislation, the way that is structured is that the offences and penalties are found in the primary legislation. Any non-compliance can lead to fines. Where they lead to monetary fines, is classified into one of the 6 levels, but somewhat confusingly, the fine levels are not found in the company's ordinance. They are found in a separate legislation called the Criminal Procedure Ordinance, Schedule 8. So when we look at the primary legislation, if it's an offence, you see the punishment and the penalty that's involved. Now, where the regulations, that is the subsidiary legislation that can be promulgated by the Financial Secretary, that in such a case, the regulations do contain provisions for non-compliance. But the way that it works is that the primary legislation explicitly provides the scope of the power of the Financial Secretary to issue regulations relating to the offence. So in other words, if the regulations allow or provide provisions on the offences, there are curbs onto how the punishment on the type of punishment that can be imposed by the Financial Secretary, because the primary legislation will set out the power of the Financial Secretary as to issue regulations dealing with this offence, together with the punishment that cannot exceed a certain level of fine. So the scope of the power of the Financial Secretary in this regard is quite circumscribed. The advantage is that when one looks at the main legislation, one can have a very good idea as to what happens when there is an offence committed at the subsidiary legislation level and the consequences that follows. So what are some of the remaining points for consideration? The prospectus disclosure requirements. So it's a similar position that happened in Singapore a few decades ago. Prospectus requirements were contained in the company's legislation. Now in Hong Kong, what has happened is that when there was a rewrite exercise, it was anticipated that the prospectus disclosure requirements, which were in Chapter 32, will not migrate to Chapter 622 because they don't relate to ordinarily company law issues, but they will migrate to the Securities and Futures Ordinance. However, this hasn't taken place yet. So instead, the prospectus disclosure requirements continue to remain in Chapter 32, and the company's registrar issues guidance on the requirements on how prospectuses are to be registered. Now, prospectuses are also, in addition, subject to the dual filing requirements under the Securities and Futures Stock Market Listing Rules. This is a framework where listing applicants and listed companies are required to file applications and disclosure materials with the Securities and Futures Commission, as well as with the Stock Exchange of Hong Kong. The reason for the dual filing is to enable both the Securities and Futures Commission and the Stock Exchange of Hong Kong to be able to exercise their respective enforcement powers. So on a question that has risen in the previous presentations, there is no merger of the insolvency provisions for corporate and personal insolvency. So instead, the Chapter 32 contains the provisions in relation to winding up, as well as all the provisions connected to winding up, such as actions for unfair preference, as well as for undervalued transactions. So I move on to the Securities Regulation. So in 1999, a consultation exercise was carried out on having an omnibus securities legislation. The view was to be able to consolidate and modernize a total of 10 pieces of legislation on financial services, securities and futures markets, as well as on investor protection. This is also the framework that introduces the dual filing by both the listing applicants and the listed companies to the stock exchange, as well as to the Securities and Futures Commission. And both authorities can investigate if there's false and misleading statement filed. The disclosure, or rather offences relating to disclosure of false information was introduced. There's a new private right of action to seek compensation for losses arising from reliance on false and misleading statements. And auditors of listed companies have immunity from civil liability if they report suspected corporate misconduct of this to the Securities and Futures Commission. So initially, there were 36 sets of subsidiary legislation in order to operationalize the Securities and Futures Ordinance, or the SFO. And just a quick note that the prospectus disclosure requirements are still contained in Chapter 32. So SFO is the overarching legislation on regulating securities and futures industry. The power to issue subsidiary legislation, and in this context, there are called rules on licensing, for example, fall with the SFC. In certain specified areas, for example, on which kinds of schemes can be designated as collective investment schemes, the power lies with the Financial Secretary. The SFC issues a number of codes and guidelines which are explicitly not stated as subsidiary legislation. So, as in the case of the company's legislation, when it comes to offences and penalties, these are all mostly found in the primary legislation, where the subsidiary legislation, also known as rules, contain provisions on offences. The primary legislation explicitly provides that the SFC has the power to issue rules dealing with both the offence and the punishment. And the punishment, the scope of that discretion to issue the punishment, again, also is listed in the primary legislation. So in that sense, when one is looking through the main legislation, you will have a good idea as to what happens when there's a breach, not just of the main legislation, but also of the subsidiary legislation, because it was states the consequences, which cannot exceed a certain number of years or a certain level of fine. Now, just some reflection. The way that securities regulation is enforced in Hong Kong is primarily with the public regulator. In theory, you can have private enforcement because the SFO provides for it, but that is extremely rare. And often breaches can lead to several potentially overlapping offences. So in the work which I've done on the comparative enforcement of securities regulation in Hong Kong, I just take two examples. The first one relates to the misrepresentation or the making of false and misleading statements to the securities market. So this chart here shows the consequences. You can have civil remedies. You can have criminal sanction. There is no civil penalty orders. The civil penalty orders are largely confined to offences relating to insider trading and other market misconduct. But for false and misleading statements, what you have is you have the civil remedies, criminal sanction, and of course also disqualification of the directors. When it comes to civil remedies, there is compensation upon the breach if you can establish all the elements are being met in the specified requirements. But the reality is that when it comes to the actual enforcement, that there are actually very, very few actions which are brought by the aggrieved individual investors. A lot of the enforcement that happens outside is brought by the Securities and Futures Commission. So in that sense, the SFC has some similarities with ASIC in that a lot of the breaches of the securities regulation relating to false and misleading statements, they are carried out by the public regulator. Now, for prospectuses, so what I've stated earlier is in relation to false and misleading statements to the market. So for prospectus, so that's the selling document which is used to initiate sales. In such a case, you also have civil remedies. You also have criminal sanctions, and it also has a statutory compensation which occurs upon breach. Now, in such a case, so these are what I would term the IPO related situations where there are false and misleading statements. In theory, you have a statutory compensation order, but in reality, the enforcement also lies largely with the regulator. So that concludes my presentation. I would now hand the presentation over to Justice Colvin.
Thank you, Wei Yi. I was interested to see in that presentation, as well as a comprehensive understanding of how matters are dealt with in relation to hierarchy and structure, particularly concerning penalties, the way guidelines can be used as a kind of form of soft law, but with possible consequences in the event that there is a contravention raised. Something also raised in the context of the UK approach. So thank you very much for that presentation. We have some time now to put questions. The interest's been considerable and we'll not be able to get to all of the questions, obviously, but I should say that we value all of the questions and issues that have been raised. This seminar is an opportunity for the ALRC to understand what sort of questions are being asked and what issues are being raised, and we will review all of those materials following the seminar. So they're of considerable assistance to us, and we thank you for taking the time to raise them. I'll put the first question to Julia, if I may, about the principle-based regulatory approach and the fact that the UK is often held up as having successfully pushed a lot of detail down into the delegated legislation, particularly the way in which the regulator can make those rules. I wonder how well that has really worked in your view, and whether Brexit is changing any of that approach, or post-Brexit, I should say.
Yeah, absolutely. Thank you so much. I think the first thing to say is we've got two things going on in the UK. So we have the enabling framework of legislation, which provides some overarching goals of the regulator, and then a list of things to which they have to have regard. Some are procedural, like accessibility and proportionality. Some are substantive. And then what we have is quite a significant delegation of powers to the regulators to then formulate their own rules. Then what the regulators have done on both sides is themselves set out principles and then a series of detailed rules. So we have two things: the enabling framework, which sets out the perimeter, the core obligations, etc., and significant delegation. And then within the rule framework, the rule system that the regulators have produced, that principles followed by detailed rules. Now that was that then, in terms of a sort of overarching design set, as it were, did get sort of knocked sideways a little bit by the EU legislation coming in, because of course that came in sideways as being directly applicable. So we had our UK framework, and then the bits that were taken over, as it were, by the EU, we had a different sort of dynamic going on, but the regulators still had their principles and detailed rules. So now what we've had is a complete, there's a lift and shift of all that EU detailed, directly applicable regulation into all sorts of bits of our legislative, sort of rule hierarchy, such that it is all kind of topsy-turvy and frankly quite a mess at the moment, and certainly not accessible. And so the regulators are keeping their principles. And then what we're doing is, as I say, that great sorting out to go back to that enabling framework idea, the sorting out, the more detail in delegated legislation, which is where you have more details about the regulatory perimeter, for example, and then leaving the bulk of the heavy lifting to the regulators. But what you have now is our financial regulators resuming a quite active policy making role, which they had back in 2000, but then gradually lost as more as that competence went over to the EU. So we're revisiting debates we had about 20 years ago, to be honest. So that's what's going on. In terms of the overall success of the principles-based regime, it is worth bearing in mind that although there are those 10 principles, 11 principles out there, they are supplemented by vast reams of detailed rules. So we don't just rely on principles alone. But what they do is that role of communication, kind of communicating quite clearly to firms, you know, treat your customers fairly, engage with the regulator, you know, act with integrity, and they are very important for enforcement because what they enable you to do is have those overarching standards. So when a firm hasn't necessarily breached a detailed rule, but you've gone against the kind of the spirit of it, or it's not covered by the rule, then you do have these principles against which you can enforce. And so they have been very useful, both as means of communication, things at board level, people at board level can get hold of, who are never going to go down into the level that lawyers are going to go down into. And also as a way of driving enforcement action.
Seem also to be a matter that you referred to earlier, a way in which the expertise of the regulator can be harnessed by having that broad principles approach and then the rulemaking power, provided you've got a good, well-informed, resourced regulator, you should get a good outcome through that process.
No, absolutely. You should exactly. But as you say, it has to be well-informed and well-resourced regulator to enable you to have that cadre of expertise. And then I know the issue always comes up with lobbying in relation to firms, but I think it's worth bearing in mind that, you know, regulators who engage with firms on a day-to-day basis know their business very well, know the business of those firms very well. And they know the detail very well, and they know the technical provisions very well. Politicians who don't engage with firms on a business level have a different relationship with firms. I'm not saying they're particularly more susceptible to lobbying, but they might not necessarily know what kind of questions to ask or how to understand the answers that they're then given.
Yes, yes. I'll switch gears now and ask a question of Ross. I must say, looking across the ditch to New Zealand, there seems to have been quite a lot of work put into the structure around getting good legislative design and the guidelines that have been prepared and adopted by the Legislation Design and Advisory Committee appears to have had a positive effect upon the approach to legislation. Do you think that has worked because of things peculiar to New Zealand, or do you think it's something that might be adopted in Australia in a similar sort of vein?
Well, thank you, Judge. I think New Zealand's Legislation Design Advisory Committee, or LDAC, is a good model. It's an expert committee that can assess proposals as they develop, and it can record and make known principles and best practice. And certainly it had a role in the Social Security rewrite that I mentioned. I know that Australia's constitutional arrangements are much more complex than New Zealand's, but good design principles, I think, most probably can be developed and applied within a constitution's heads of power or jurisdictional limits. I'm aware that the Australian Government Office of Parliamentary Counsel under First Parliamentary Counsel Meredith Lee has a lot of online drafting resources and drafting manuals, and in my experience is very careful to consider design concerns when developing schemes. So I think that like other centralised law drafting offices, the Australian Government OPC works with others to frame legislative proposals. And it's most probably like New Zealand's Parliamentary Counsel Office, and that OPC's goal must also be to to promote high quality legislation that's easy to find, use and understand, and in that sense to exercise stewardship of Australia's Commonwealth legislation as a whole. So yes, our experience is that the design committee is very valuable, and I would think if it were to be adopted in Australia, it might add value as well.
Is the proposal to migrate those authorities which have their own regulating making power to, how does that fit in? Are they going to migrate over to be within the structure, or is that a bifurcation that's going to stay in place?
So our Legislation Act of 2019 contemplates a move to centralised publication. The making arrangements will largely remain as they are, but the publication arrangements will be centralised over time. There's quite a long and complex transition contemplated there, but in time, the objective is a single website, which obviously will assist accessibility a great deal and may also assist with uniformity of approach in terms of drafting and principle. So that is certainly the long-term goal, but as those who are familiar with the detail of the transitional provisions in the Legislation Act 2019, it is a long-term goal, and there are a number of steps on the way.
You used the word accessibility there. I would encourage you to use the findability word, which I embrace. I think it's a big issue with legislation, finding where it is, particularly subsidiary kind of legislation. But thank you for your observations on that.
Surely. Thank you, Judge.
Hans, turning to Singapore, I know in Singapore, the authority to make subsidiary legislation can include the authority to make offences and set penalties, much like in Australia. Do you have any insights as to how that has worked in Singapore in the context of financial services legislation?
Thank you, Justice Colvin. Yes, Part 3 of the Interpretation Act provides that offences can be created in subsidiary legislation, but that results in a fine of a maximum of $2,000, a jail sentence of 1 year. I think it has worked well with less serious offences in the company's regulations, where there can be a composition of fines, which is effectively a settlement with ACRA. But given the complexity of things and also the continuing need to retain more serious matters in primary legislation, I wonder if actually more can be done by way of subsidiary legislation, the way it appears to be in the UK. And here I defer to Julia, who I think mentioned something along these lines. It seems that subsidiary legislation quite often can amend the Act. For example, the Companies Limited Liability Partnerships and Partnerships Amendment, EU Exit Regulations of 2019, amends the Companies Act of 2006 with respect to the treatment of overseas companies. I'm not sure this was a Brexit sorting out matter, but in Singapore, however, delegated powers can allow administrators to amend acts or modify the application of acts, but only where these must be drafted with a sunset period of 2 years. So I'm not sure if that is the case in the UK or if actually it's broader than that, or in Australia as well. But again, I'm quite comfortable with delegating more power to administrative agencies. In Singapore at the moment, it is only in highly exceptional cases that the Principal Act may provide for it to be changed later by subsidiary legislation when these changes are anticipated. Thanks, Judge.
Yes, thank you. Sounds like in Hong Kong there's quite a clear limit on the consequences that can follow through delegated legislation, the type of penalty that might be imposed. So there's only a certain type of penalty that can be imposed by delegated legislation. Is that right? I think we've just lost the connection. So having asked that question, Hans, I'm sorry if you can still hear this. I apologise, but we'll go to Wei Yi now in relation to the next question. I know you've done a lot of comparative work in the area of corporate insolvency and consumer finance. I wonder if there's any experience or insight from elsewhere in legislation that you think would be useful for Australia when it comes to the overall approach to legislative design for financial services legislation.
Thank you, Judge, for the question. So in relation to the corporate insolvency laws, now Hong Kong doesn't have a formal corporate rescue regime as yet. There were a lot of discussions, and possibly it might be introduced. It might be introduced sometime this year, but it doesn't have a formal corporate rescue. Now, unlike in Australia, where there are several means or modes in which a debtor company which is in financial difficulty can undertake a corporate rescue. So the question that often arises is where is the best place do we put these provisions? To put in a legislation which states at the outset that it is bankruptcy related or insolvency related does carry some kind of a stigma. Whereas if you put it into a legislation relating to corporations law and you term it restructuring, it might carry less of that stigma in question. So this is always one of these issues as to the actual way that it is presented to the public does matter, because if we have want to encourage more businesses to undergo rescue if they are still economically viable, it might be more difficult to sell that process if you put it into an insolvency legislation as opposed to a corporations type legislation. So in relation to the question on the consumer finance, so that's back to how Hong Kong has done, which we have the Securities and Futures Ordinance, and it has several situations in which you can get statutory compensation. But a lot of it is on the basis of taking the existing legislation and then adding new provisions, the result of which you have a number of overlaps. Now, if there is a chance to be able to redesign it, I think it would be ideal to be able to sort out some of these overlaps, reduce them as much as possible, so that the legislation becomes easier to understand and much cleaner to comprehend. Thank you, Judge.
Yes, thank you for that. I mean, the way our legislation is at present, we have corporations and financial services melded together. So those observations are of relevance to whether that approach is an appropriate one. It's my task now to bring our seminar to a close. We've been delighted to host such expert panelists, and I thank each of them for their careful presentation, their thoughtful and valuable insights today. It's been a privilege to hear from each of them, even through this strange method of technology that we get used to more and more as time goes on. I do feel that the absence of applause is always rather odd at this point, but the virtual applause is extended to you, and thank you for your presentations. I also thank all the attendees for their interest and for the questions. As I indicated, those which have not been addressed today will still be considered as part of our process, and the ALRC is keen to hear from as many people as possible through this process of trying to deal with approach these questions. Finally, a quick plug. The ALRC is hosting a webinar on the 17th of June at 11 a.m. Western Standard Time. It will address the feedback that's been received on our interim report A. The title is What We've Heard and Where to Next, and you can register on the ALRC's website. Attendance on that occasion will also be possible in person at the #1 court in the Federal Court in Perth, where I will be. So I hope to see some of you there in person. So with all of that, we conclude today's seminar. Thank you for your attendance and good evening.